Yeah, so welcome everybody. Today is Wednesday, August 25th, and you're joining Homeline at 1:30 in the afternoon for another one of our eviction phase out COVID-19 eviction moratorium phase out webinars. My name is Eric Hauge. I'm the executive director at Homeline, and also joined by Homeline staff, Rachel Sterling, our COVID-19 eviction response coordinator and housing attorney, and our managing attorney and hotline director, Mike Vra, for another one of these sessions. And today's guest speaker that we're excited to have is Katherine Kelly, who's the Assistant Attorney General at the Attorney General's office here in Minnesota, to cover a little bit about the Attorney General office role in the eviction moratorium over the past year and a half that went from March of last year through June of this year. And we'll get to Katherine in a little bit here. Before we get started, we will do a brief overview of the current situation on the phase out here in Minnesota and the CDC eviction moratorium. And before we pass it over to Katherine, a little bit of logistical things quick before we get started. A reminder of what Homeline is. We're a statewide nonprofit organization. We provide free legal, organizing, education, advocacy services for renters. Our main program is a free and confidential legal hotline for renters. And we speak to folks in English, Spanish, Somali, and Hmong languages. And we've advised over 265,000 renters since opening. There's our hotline, and you can also contact a specific language line or contact us over our website and email an attorney directly at that link at the bottom. And again, today we provide some general legal advice and information, but we strongly encourage renters to call us if you have questions about your specific situation. We do have a number of eviction moratorium phase out resources on our website, including recordings of all our previous webinars and links to future sessions, and a timeline and FAQ on the eviction moratorium phase out here in Minnesota. The next scheduled webinar we have is 2 weeks out. We're skipping the beginning of September and having a little bit different webinar on Wednesday, the 8th of September. And so the information about that's on your screen. We're having a 1 hour session in the evening that will be broadcast in multiple languages, in English, Spanish, Somali, and Hmong, live translation, live interpretation. And it's going to be a overview of the phase out law and the situation we're in, including resources for tenants, really designed for an audience of renters and advocates individuals that work with renters. And I will put links to all these in the chat once we get started, so you can register or get a reminder email about this seminar on the 8th. And as always, we want to remind folks of the two kind of key rental assistance programs in the state. renthelpmn.org or dialing 211 will get you information about the Rent Help MN rental assistance program, which is one of the key program in the state that's identified in the phase out law. That's very important for people to apply and get their applications in to initiate some of the protections under the phase out law. There's also the zero, and that program is statewide. There's also the Zero Balance Project that is just in Hennepin, Dakota, and Ramsey counties that is landlord initiated. And we have had webinars on both of these programs with staff from these agencies in the past, and so you can look those up on our website. But now, before we kick off a conversation with Katherine, Mike Vra in our office is going to give an overview of where we're at right now in Minnesota with the eviction moratorium phase out, the CDC moratorium. We do want to reiterate that we'd like to field questions throughout this. So please, if you have questions about the current situation, send them in. We'll get to them. Also, if you have questions for our guest speaker throughout the seminar. Please use the Zoom Q&A question and answer feature, as it's easiest to track questions that way versus chat. So thanks for joining us, and I'll pass it over to Mike.
Thanks, Eric. I'm guessing I'm going to talk for about 20-25 minutes, as you said, to sort of update where we are in the eviction moratorium off-ramp phase-out status. And then Katherine will be joining us. We'd prefer to have the questions directed towards her. She's going to be talking about the Attorney General's role throughout the pandemic and what their role is currently as well. But please direct your questions to her to start. And if there are additional questions at the end, then we'll try to answer those as well. I have been gone for a few weeks and am lucky to work at a place where we have such capable talent that was able to step in and help out with the webinars. So a special thank you to both Rachel Sterling and to Samuel Spade, two other attorneys in the office that have been filling my role very, very admirably. So thank you to both of them. And I do want to talk briefly about the speech that we have set up for the 8th of September. This is the first speech that we're going to be giving in this manner that's going to be interpreted in a live setting. And our goal is to reach as many people as possible. We are planning to probably do another one of these in October as well. But it is a live recording. I'm sorry, it's not a recording, it's a live show. There's no way to record the interpreted / translated versions. So if you know of people, you work in an agency where you've got a lot of folks that English isn't their main language or their first language, but they do speak Spanish, Somali, or Hmong, this is going to be a good chance for them to hear this, hopefully in a direct manner. So please pass it on to folks that you think could use that. All right. Let's go ahead and get on to the topic that I should cover, which is the eviction moratorium and where we are with that. Thanks for shuttling around the PowerPoint there, Eric. Let's start with Minnesota evictions, the governor's moratorium that we have talked about since March of last year. We're still dealing with the aftershocks of that moratorium, and the phase out of it is where we're at. So the last version that the governor had issued through an executive order was issued in 2020. It was the 79th order in 2020, but it has been ended effectively as of June 30th of this year. What has replaced it is a 6-phase phase out, is what we call it. Some people call it an off-ramp, but it's this series of occurrences and new rights being reaccumulated by landlords that were lost during the pandemic. Go ahead and take us to the next screen if you could, Eric. Okay, so as you can see, there's a lot of text on the screen. In fact, if you don't mind, phase us over to where we are right now too. Let's just go that route. Oh, thanks. So we are now on August 25th. So between August 13th and September 12th, what we're terming phase 3 of the phase out. At this point, landlords have already reaccumulated the rights that they had before the pandemic, and I'll explain what rights they've reaccumulated already. So these are rights landlords already have that they didn't have during the pandemic emergency order era that ended June 30th. So now a landlord can file an eviction for material breach of the lease. They weren't allowed to do that. Something like having an unauthorized occupant or a lot of noise or smoking in a non-smoking building. Those were not legitimate reasons to file an eviction during the peacetime emergency. Now a landlord can file an eviction for those reasons if they so choose. Doesn't mean the landlord wins the case. They still have to prove what they're alleging in their complaint. They have to show that it was something in their lease that was being violated. They have to have some language in their lease that says they have the right to evict if the tenant violates that term of the lease. So a landlord doesn't win automatically simply by filing one of these evictions. And by filing an eviction, what I'm referring to is a court case, the $300 or so court case that the landlord has to file. An eviction court case is the official name for it. They are also still referred to as unlawful detainers or UDs because they've been called that for so long in this state. They actually changed over the phrasing to evictions before this century, but everybody still calls them UDs. Anyhow, that's the court case the landlord has to file in order to ask the state to ultimately remove the tenant through the force of the state. A sheriff will come and physically make a tenant go at the end of an eviction process if the landlord wins the case and the tenant refuses to leave. And we are in phase 3. So what happened on August 13th? What did the landlord accumulate as rights go on August 13th? Well, now a landlord can terminate a lease or non-renewal lease for a tenant who is not eligible for the COVID-19 emergency rental assistance. So that's different than what the next phase is, where the landlord can file an eviction. That starts on September 12th. At least that's the state rule. We'll talk about the federal rule in a second. So in my mind, looking at all the phases that we have on the screen right now, this phase has always been the weakest of the phases, the least important of the phases that we're dealing with. August 13th was one that was less consequential. I'm not saying it doesn't matter, but it doesn't matter as much as the others. Landlords do in fact have this new right to give a notice to vacate. So a traditional notice of non-renewal would be, let's say the tenant is month to month, their rent's due on the 1st of each month. The landlord could tell them right now, you know what? You are not eligible for COVID-19 assistance, so I'm giving you a notice, month to month tenant. You have to vacate by the end of September at this point. By September 30th, the last day of the month, and if you're not gone, then October 1, I can go file an eviction for what's termed holding over. That's another reason why landlords file evictions other than non-payment of rent or breaches of the lease. Those are the 3 biggest ones that landlords file evictions for. And as mentioned, landlords didn't have that right before August 13th. They do have the right to do that now. It's not something that we've had a flood of contacts or calls from tenants about, nor did we expect that. Phase 4 was always seen as a much more important phase in this process that we're going to be dealing with. And we do anticipate that there could be a great deal, many more evictions in mid-September because of that phase occurring. There are some other things that are going to slow it down though, and we should talk about them. So go ahead and take me to the next part of I think what'll show up is that you're going to show all the phases in blue that we're up to currently. Yeah, so again, that's what we've already gone through. These rights accumulate as we go. So just because a landlord got a right on June 30th doesn't mean they lose it when we get to July 14th, phase 2. These are building up the rights that landlords had in place prior to the peacetime emergency being declared. And so when phase 4 happens, we're just going to extend that shaded box over to a new phase, but all the rights the landlords have already reaccumulated, they keep. They'll keep reaccumulating them until we get to June 1st of next year, at which point under this system, it's as if the peacetime emergency never happened legally for a landlord going forward at that point. But let's go on and talk about a couple of other parts of the state eviction moratorium. The first one is the notice period requirement. Now, this is in place officially until October 12th of this year. So even now, even when we move over to phase 4, which will be in mid-September, the landlord would still have to give a notice, a 15-day notice, that the tenant owes rent, that the eviction moratorium has ended, how much rent is due, and the information about where the tenant can get rental assistance. And so this does potentially slow down the eviction from being filed on September 12th if the landlord has not given the 15-day notice already. And as mentioned, this notice will stay in place. This notice requirement will stay in place through October 12th. Slide back to the prior screen, if you could, Eric. Sorry to keep you jumping around like this, but just looking at our phases. So September 12th, like I said, landlords can file an eviction for a tenant who's ineligible. And a landlord still needs to give a 15-day notice if they're trying to file an eviction for non-payment of rent, which, again, we've talked about this, and I know there's a lot of repeat viewers, but it bears mentioning again and again because it's really important. Almost every eviction in Minnesota is for non-payment of rent. Well over 90% historically, certainly in recent history, of evictions in Minnesota are filed for non-payment of rent. And so that's really what's mattered the most. We have talked about that since April of last year when we started doing this. When can Minnesota landlords start filing non-payment of rent evictions again? They've been able to file some evictions the whole time if tenants did some bad stuff. They had drugs in the apartment or illegal weapons or endangered people on the property or caused serious property damage. Those have always parts of those have been in place throughout the peacetime emergency. So there's always been a way to file an eviction, but in the most common way, in the almost every single time way that landlords file evictions, they haven't been able to for non-payment of rent. And that's still what we're talking about. When can a landlord file an eviction for non-payment of rent? Right now, today, the landlord still can't file an eviction for non-payment of rent in Minnesota. They will be able to on September 12th, according to this chart. Okay, so that is a big step forward. Now, it's not all the evictions that they can file at that point. They're not able to file a non-payment of rent eviction. They're not able to, unless the tenant is ineligible for the assistance. But it is a huge step in the direction of landlords, as I have called it, reaccumulating their rights that they had prior to the peacetime emergency. All right, go ahead and go on a couple slides then, Eric. The last, yeah, there you go, that's the one. The last key thing we should talk about is phase 6 of the phase out process that we're dealing with. And so this lasts all the way through June 1 of 2022. So what is it, 10 months away, 8 months away? Calendar math is tricky when you turn the calendar for me, but it's a lot of months away still. June 1st of 2022, a landlord can't file an eviction for non-payment of rent or proceed with an eviction if the tenant has a pending application for rental assistance. So that means not only can the landlord not file, which means start the case, but if the case is already started, it can't proceed. And that's in place through June of next calendar year. This is the entire phase out process was a heavily negotiated agreement between both the House and the Senate. As you all know, the House is controlled. The majority there is Democrat. In the Senate, the majority is Republican, along with the Democrat governor ultimately agreeing to this as well. And this was part of the agreement, was that that the landlord couldn't file an eviction for non-payment of rent if somebody has a pending application. What was known at the time and is still known by everybody that was trying to craft a sensible compromise solution was that the rent help process was going to take time for people. It was already very clear at that point that it was not as quick as most people wanted it, both landlords and tenants. And while it's seemed to have gotten faster, it's still not fast enough for most people. But there was this recognition that, hey, wait a second, we want landlords to get paid. They're most likely to get paid ever if it's from this giant pool of federal money that's being funneled through each state. And so we want to make landlords whole. We want tenants to be able to keep their home. And so that's been the thinking behind this off-ramp phase out that, again, both parties agreed to as part of a grand compromise that they have in place. Now, we need to talk about a couple of federal issues as well, because they play a role. Again, having done this a long time, I've been at Homeline since 1996. Almost all the time that I've worked, I have said, if I'm giving a presentation, I'm talking about state laws. That's what we're really talking about here, other than discrimination, which there's a lot of discrimination law at the federal level that matters quite a bit. But other than discrimination, federal law hasn't really mattered much in my line of work. That changed last year in April when the CARES Act came out, which was something that is sort of fading from most people's memories. It's not in the news every day, but it was in the news a lot by then, a wildly bipartisan at the federal level agreement. Both the Republican Senate and the Democrat House passed a sweeping bit of legislation that started to give stimulus checks both to people and to businesses and a lot of other things, but also had some rental applications as well, some housing applications as well. And what we care about and why we're still talking about this is because of the fact that it addressed evictions for non-payment of rent. So to start, the CARES Act only covers CARES Act covered buildings. What's a CARES Act covered building? Well, there actually is this really broad umbrella definition they used, which is any place that's covered by VAWA, the Violence Against Women Act, is CARES Act covered. And so if there's any kind of federal subsidy, almost certainly it's going to be covered by the CARES Act. Also, if the building has a mortgage that's federally backed by Fannie Mae or Freddie Mac, then the CARES Act would cover that as well. Now, this CARES Act coverage stopped non-payment of rent evictions through July 25th of last year, right? So we're not even talking about 2021. 2020 is as far as this went. But here's why we're still talking about it. There's a 30-day notice requirement that never went away. Key parts of this legislation said they were ending at various times. And on the eviction one, it was the July 25th deadline. But the 30-day notice of non-payment of rent requirement under the CARES Act never sunsetted. That's legislative speak for having a planned end date on it. And so it is still the law. And it has not really had a role yet in Minnesota because we've had in place eviction moratoriums that have offered much more protection to tenants than the CARES Act really did. And so it hasn't played much of a role, but it could when the eviction moratoriums start to disappear on us. So is it possible that a landlord could file an eviction on September 13th for non-payment of rent, or September 14th for non-payment of rent for somebody who's ineligible or is refusing to apply for the rental assistance? Maybe, but they might have to comply with the CARES Act requirement as well of giving a 30-day notice. And so the landlord might not have done that. It's going to be a starting question, a defense, certainly for every tenant advocate, whether they're a lawyer or a tenant advocate for themselves or somebody else that might say, Judge, wait a second, CARES Act, I think that applies here. There's no 30-day notice given, might be a winning defense for a tenant. Again, we haven't seen it used in Minnesota yet. We haven't really seen it used nationally all that much because there's only been so many windows in time where there wasn't either the CARES Act or what we're going to talk about next, the CDC eviction moratorium in place. In fact, let's go to that if we could. The CDC federal eviction moratorium is still in place. We still have it. It was supposed to be gone at the end of July. We were told it was going to be gone, but then the CDC reinstated it after a few days of not having one. And this is nationwide. If we're in a county, that's how they look at this, county specific. If a county is experiencing substantial or high community levels of transmissions of the COVID virus. I'll show you a map in a second, what Minnesota looks like when it comes to that. But it's not every place. There are, I think, 4 counties in Minnesota where it isn't covered right now, so it wouldn't play a role. Once again, this only works for non-payment evictions. It defers to stronger local protections. And right now in Minnesota, we still have stronger local protections. But this is the last 2 points on this page are probably the most important from a Minnesota perspective. This could wipe out the importance of the September 12th phase where the landlord can file an eviction for a tenant who's not eligible for the COVID relief or is refusing to apply. At that point, the CDC order, if it's still in place, would require that a tenant provide what's called a declaration stating several things, that their income is under a certain level, $100,000 per individual, up to $200,000 per household, that they've exhausted everything that they could to try to come up with the money, and that their inability to pay was somehow COVID related, health related expenses, job loss, things like that. So far, the CDC declaration hasn't been required in Minnesota, so we don't have much experience in giving advice on it. It hasn't mattered here in this state, not really. But it could on September 12th. We might be telling tenants repeatedly and in sessions like this that, hey, the CDC declaration, you should fill it out right now, get it to your landlord to make sure that you're covered with the protection, which goes through October 3rd at present of 2021. Now, the last bullet point, court challenges. All right, so it is not wise to predict how the Supreme Court's going to rule on things. We're talking about the federal Supreme Court right now, not that it's easier to predict what the state Supreme Court might do about something, but right now the federal Supreme Court is as near as I can tell, as we speak, perhaps, considering what to do about the eviction moratorium. There were over a dozen court challenges around the country to the CDC's moratorium throughout the months. And the most recent one that was really important went all the way to the US Supreme Court. And in a 5-4 decision, the Supreme Court decided to let the CDC eviction moratorium remain in place. However, Justice Kavanaugh pointed out that he didn't really like the decision, but the decision was only going to matter for a couple more weeks. So because of that, he was sort of okay with saying, yeah, let's keep it in place. It was a kind of a strange rationale, but that's what his concurrence, I guess, is the right way to phrase this. It's kind of an odd decision in the way it was issued. His concurrence indicates, though, that if the CDC decided to renew the eviction moratorium again, that he would vote against it. He seemed to also indicate that if Congress had passed an extension of the eviction moratorium, then that would be okay with him. That didn't happen. Congress tried, at least parts of Congress tried, and other parts said no, and so it didn't get through. So that's why the CDC came back and reinstituted the eviction moratorium in place now through October 3rd. Also, of course, citing the Delta variant and how things have changed from when Justice Kavanaugh issued that decision to the state we're at right now. So, as mentioned, there's actually a real chance that sometime during this speech, the Supreme Court will issue a decision. We have somebody that's sort of keeping an eye on that and will let us know if it does happen. Because it happened fairly quickly last time. The Biden administration submitted their counter to the Alabama Association of Realtors, that's who's representing landlords here, on Monday of this week. And they were only given a few days to submit that. So it indicates that the Supreme Court is thinking about making a pretty quick decision here on whether the CDC moratorium will remain in place or not. As it stands, it still is in effect, but it is, I think there's a high chance that it gets stricken at this point. But you never know what the Supreme Court's going to do until they actually do it. Now, I mentioned earlier, this only applies to counties. The CDC moratorium only applies to counties where there's a high or substantial level of COVID transmission rates. As you can see, these are all, well, all but one of the 3 counties that is moderate or better being fewer transmissions, borders on the Dakota states. It's very westward looking, where the population density is a lot lower, is the easiest way to explain why we're seeing the chart we're seeing. And vaccination rates matter a lot for this sort of thing too. But anyhow, most of Minnesota, I think there's 87 counties, so 83 of them would fall under the CDC moratorium on evictions. Also, this is one other change in how the CDC presented this new order. And one of the arguments they made at the Supreme Court level in their submission that they put in on Monday was, hey, wait a second, it's not the same eviction moratorium that we had in place, which covered the entire United States. This is a targeted exception. And so if the county has a low rate for 14 days or more, then the eviction moratorium is no longer in place in those counties. So it is a slightly different order than the CDC had issued originally. Now, again, looking at the phase out period one last time that we have in Minnesota. And does the arrow show up there? Wow, hey, wow. I guess it does. So that is where the CDC eviction moratorium intervention really matters in Minnesota, is between September 12th and October 12th. And it would push things to October 3rd, that a landlord wouldn't be able to file evictions against those September 12th tenants that they might have been able to file evictions against before, if the CDC eviction moratorium remains in place. I cannot imagine that we won't know the answer to that by that time, by September 12th. I think the Supreme Court wants to fast track this. They have before. For them to take 2 weeks to make that decision would be shocking to me, but I guess you never know. They can do what they want. They're the Supreme Court. Who's going to tell them how to run things? Okay, well, that was my 25 minutes. So, like I said, we will take questions about the eviction moratorium phase out off ramp later if we have time for them. But next up, we're going to have our guest speaker, Katherine Kelly, is going to join us. Now, Eric referred to you earlier, Catherine, as the Assistant Attorney General. There's more than one of you, right? It's like a vice president at one of those giant companies. There's more than one vice president at GE or wherever.
That's right. There's many of me.
How many are there? Do you have any idea how many Assistant Attorney Generals there are?
I believe that there's 220. No, 150. I clearly have no idea.
Yeah, those are both numbers. Right. Okay.
I want to be clear. I said the because I have a favorite one.
Well, sure. So now, Catherine, you don't have any sort of prepared presentation, at least not slides that you don't have, right?
I have information, but no slides.
Okay. Did you want to start by simply sharing what you wanted to share, and then we'll start asking you questions, both from Rachel and I, but other questions that come in from people that are watching as well?
Absolutely. Happy to do it.
I will step back.
I'll take it away. Thank you so much. Hello, everybody. Thank you for having me here today, Homeline. I'm a little bit laughing because when Homeline first reached out and said, would you like to do sort of like a retrospective? I thought, sure, COVID will be behind us. It'll be in the rearview mirror. It'll be a trip down memory lane. And here we are with the Delta variant, and it's not in the rearview mirror. Anyways, I'm still doing a retrospective of what the Attorney General's office did during COVID, and I'll end with what we're currently doing, COVID or not. So I'll just start with the beginning of the saga, which is March 24th, 5 p.m. 2020, the governor's first executive order on evictions went into effect. So it was Executive Order 20-14, and it prohibited eviction filings, tenancy terminations, with very few exceptions. Those exceptions over time got a little bit bigger, but at the beginning, there were very few exceptions, kind of like what Mike was saying, drugs in the home, weapons in the home, prostitution in the home. That was always my favorite category of exemption from the executive order. And that actually did come up. So anyway, so once the governor's order went into effect, very quickly, our office created a process for how do we enforce the governor's eviction moratorium, because a law is only as good as its enforcement, right? So the courts were a good gatekeeper for eviction filings, right? They just said, no, we're not going to take your filing. Governor's order says that we can't process this right now. And so most courts were doing that. However, that didn't stop landlords from terminating tenancies, from texting, emailing, giving a notice that said, get out by April 5th or get out by August. So without enforcement, those tenants would not be protected because a lot of tenants had no idea they had any protections at all. And honestly, a lot of landlords didn't know that they were being regulated all of a sudden when they never had before, in terms of when they could tell a tenant that they had to move, even if the lease was up, right? So governor's order went into effect. We then created a website. It's on our website. It's a form on our website specifically for reporting those violations. Tenants could fill it out saying, my landlord just told me they're gonna, kick me out next month. What do I do? Landlords could fill it out and say, I heard I can't do this. What's up with that? We had our community partners like Homeline, Legal Aid, Volunteer Lawyers Network would refer cases to us. They would fill out the form and say, I just found out this building is given a notice to all units that they're going to end end tenancies because they want to sell the building or remodel. We saw a lot of remodeling issues come up, because summer is kind of the time in which buildings would do that. And I learned that quite a few landlords will just clear house for a couple months and remodel and then try to sell the building. So even those were stopped during the eviction moratorium. So what we did with those reports were we enforced the law. So we had a pretty large team at the office. It was not at all just me. I think at one time we were up to at least 20 lawyers working on this, depending on the cycles of when landlords were violating it, when we got in the news, when reports came in. And so we would contact the tenant for more information, get a copy of the actual notice, or just gather more information, and then contact the landlord as well. And we would ask the landlord, and we generally started with a very light touch, I would like to say, because we considered it education at first. And then of course, if the education didn't work, our enforcement would ramp up in effort and force a little bit. So it would reach out to the landlord and say, hey, we received a notice that you gave a notice to vacate effective August 1. You might not be aware, we have an eviction moratorium. The governor says that you need to meet this criteria to terminate a tenancy. And then it was a process of educating the landlord, telling them what the rule is, when it might expire, which was always difficult because they were enrolling 30-day increments. So we never could say when it would expire. We'd say, check the news in the middle of the month to see if it's been extended. And then we would try to gain the landlord's compliance and promise to comply over the phone. If they did so, then we would send a letter memorializing that understanding and giving them some education and information in writing, because a phone call is different than having a letter in front of you. And then we would also supply the tenant with that letter as well, so that they would understand that their landlord had been contacted by us, and they too would have the education and the information in writing. They would also know who to reach out to at my office if they needed to follow up, because a lot of these files involved a lot of follow-up, because the landlord might comply and then their patience would wear thin. And then they would stop complying and we would need to recontact them. Or they would just think it had expired because they heard something in the news that the CDC rule, was wrapping up. And so they thought that that meant the Minnesota rule was wrapping up, not realizing they are two separate schemes, as Mike just said. So we would then reach out again. We did that from all the way from the end of March, pretty much the day after the governor's order went into effect, through, actually, we're still doing it. I was going to say we ended when the eviction off-ramp, the legislation passed, but we actually are still following up. So I'm going to give, I'll talk about that, but I'm going to give some data about the last, 16 months that we had. So we received over 3,200 reports of landlords violating the eviction moratoriums, all the way from 2014, which is the first executive order, until it was 20-79. So that was the 79th executive order that the governor issued on any topic, not just evictions. So in that time, that means we received reports from over 3,000 tenants. And we know that that meant far more tenants were actually affected by our landlord's violation of the governor's executive order, because we only get reports, it's like the tip of the iceberg situation. If one person's reporting it, it's happening to a lot more. Also, a lot of times the report would be from one tenant, but they would say that the notice or the violation is applying to the whole building. That could be 10 units or it could be more. So those reports really show a lot more violations and a lot more people that we were able to help. So we always contacted the landlords. So that means our office spoke to at least 3,000 landlords during that time. And I know that we actually spoke to more than that. And which is interesting, because Homeline talks to a lot more tenants than our Minnesota Attorney General's office does, right? We're not typically in the speaking to tenant business, unlike Homeline. However, I think our office talked to far more landlords over that time, because Homeline doesn't, call landlords and mediate, at least as far as I'm aware. So, but that is what we did. Every time we got a report, we would contact the landlord. And I'll just be honest, to toot my own horn, we were told many, many times by landlords it was actually a really nice service. Not that anyone wants to get an enforcement call from our office, but a lot of them just really appreciated the education we could give, resources we were able to provide. And it's not often you get that hand holding from a government regulator or a law enforcement office. So I'm pretty pleased that we were able to offer that. That said, every now and then our education didn't work. And the nice touch wasn't working. So we would have to sue. That's what law enforcement does when someone doesn't follow the law. So we filed 9 lawsuits. 8 of them are resolved, settled, satisfactorily for us. The law was enforced and the landlord agreed to abide and sometimes pay restitution to the tenant if they suffered any out-of-pocket costs or anything like that. One of the lawsuits, in fact, the first one we ever filed, is still being litigated. So our work is not done on that front. That is just the data on the reports that we took and the work that we did. Today, we are still enforcing those orders. So that sounds kind of funny. They ended. Why are we still enforcing it? Well, we're still being told, and we still have a form. It has changed, and I'll go into that. But we still have a form where tenants can report during the effective time of the governor's executive order, so up through the end of June. If a landlord gave a notice to vacate that violated the governor's order, and perhaps it's not perhaps it didn't take effect until now. Perhaps they got a notice back then that said, come August 1st, you're going to have to get out. Well, because it was given back then, it's not effective. It violated the law. It should be considered void. And maybe now the tenant's now feeling that effect. We will still reach out to the landlord and talk about what that notice was and how it violated the law. So we're still encouraging reports for violations of the executive order prior to July. So I do want to be very clear, our office is not in the same manner actively enforcing the off-ramp. That's the phase out. There's a lot of phrases for it. That's the legislation that Mike just gave a great overview of how it's sort of phasing up evictions and notices to vacate. That is it's a law that I want to say it's a statute, but it's not a statute. It's a session law, but it was, both houses passed it, the governor signed it, and it is a law. And in that regard, our office can enforce it. However, because we are not under the governor's executive order, we're not under the governor's emergency order, our office does not have the massive enforcement reach that we were doing prior. We are still taking reports of the off-ramp, and if we are able to reach out and help, we will, and if we can't, we won't be able to, and we're very explicit about that. We can't help everybody right now. So that's where we are right now. We have a form. It's on our website. If you go to, I'll put it in the chat when I'm done talking, but if you go online and you fill it out, it allows tenants out there to report any concern they're having with their landlord violating the law, not just the off-ramp, not just something related to COVID, but frequent refusals to make repairs, security deposit withholdings that are not appropriate, violation of privacy, all sorts of those issues that tenants face at any regular time. Tenants can report those concerns to us. They are not likely to get a response from our office. That is more of a one-way information. We take that because we have a team of enforcement, attorneys who will review the data. It goes into our database. We track how many reports we receive against a particular landlord. So of course, the big corporate landlords we get more reports on, and the smaller mom and pop ones we may never get a report on or get one on. We use those reports to look for trends, to see what's out there in the marketplace. That is one of the ways in which we build our law enforcement actions, our big ones that take years to resolve and really significantly affect the marketplace. So we encourage all tenants to report that to us. And I apologize if you don't get a response, but we really appreciate the report that you're giving us. So that's it for my prepared spiel, Mike, and I'm ready to take questions.
Okay, and I think Rachel's going to be joining in the conversation as well. Maybe Eric too. It looks like he poked his head in. But I did want to talk, because this is fascinating to me, from a historical perspective, but what was it like at the beginning of the pandemic? You said that the governor made the announcement 5 o'clock one day, so you're running a tenant hotline the next morning, or how did that work?
It almost was that fast, which is kind of fascinating. So we were actually really well positioned to respond that quickly. We have a current Attorney General who feels strongly about outreach and also technology. So the year prior, we had been investing in new technology for our office, including online complaint forms. Traditionally, our office has not really facilitated online reporting from the public, but Attorney General Ellison had sort of made that a priority. So we had new staff that could do that. And so I literally could just go to our IT department and say, I need a form and I need it tonight. And here's what it should look like. And let's get this going. And they were able to make email addresses for us, the form, a database that we could log into remotely, because a week afterwards, we all were sent home. I'm currently in my closet. So we actually really did do it very quickly. And then we probably started making calls to tenants the day after. So on March 26th, we started calling people on the weekends even.
So how many people were actually sort of devoted to this hotline, for lack of a better thing to call it?
Yeah. I I would say, well, devoted is hard. So if you're saying man hours, I could do that maybe a little bit better because, this was the challenge during COVID that a lot of people faced is we also still had our regular work. Our cases didn't end. We still had court deadlines. So if we were in litigation, we had to keep litigating. A few of our cases were slowed down by the courts automatically, like everywhere, but a lot of our work continued. So we didn't have any one person completely dedicated. We had a lot of people who were doing this half-time, 20% of the time. I had a few people in other divisions that were doing this, 2 hours a week. It's wherever we could get resources from our office. So I don't have a good number for you, but it was, like I said, up to about 20 at any given time.
How did you train people effectively and immediately to get ready to answer these questions that nobody was asking the day before because that law didn't exist?
Yeah, good question. So we started by using people in the office who already had landlord tenant experience. We had a few people who had volunteered at Homeline and have retained their wonderful knowledge. We had several people who had come to us from the legal services. So Smurls and MMLA, they had clerked there or worked there prior to coming to our office. So we kind of found those people and, plugged them in because they could get up to speed much quicker. Other than that, it was just nightly trainings and a lot of phone calls.
And everybody complains about something during COVID, and sometimes it's sort of hard to sympathize with people, but I assume that there were a lot of long nights and weekends that you and people like you were working.
Oh yeah. Very, very long nights because, like I said, the regular work had to fit in. Sometimes it was at night. Although honestly, a lot of the enforcement work, the governor's enforcement work, was done at nights, on nights and weekends. It was easier for us to get a hold of landlords on nights and weekends. So, yeah, very, very long nights.
Well, Rachel, I'll let you jump in.
All right. Looks like we do have a question from John Buda from Smurls. Any idea how many complaints the AG's office has received for violations of the off-ramp legislation so far? So improper termination notices, evictions filed in violation of the law.
We're talking about just stuff since June 30th from John's question. Is that what you're gathering, Rachel? Okay.
Good question. So I'm going to give you a number because I know the answer, but it's not representative, right? I don't think you could ever take this number. I'm going to give you and extrapolate it out as to how many violations are actually occurring. So that's my caveat with data because I respect data, but I and other people in my office review the forms. A lawyer always puts their eyes on the forms that we receive, the tenant form at least, not the regular consumer complaint form. But for the tenant forms, we're getting on average about 2 reports a day of the off-ramp being violated, meaning I was told to vacate, but there's no material breach of the lease. They don't satisfy the eligibility criteria that Mike went over. It's about 2 a day.
And you don't have the same enforcement power that you had under the executive order that you do now, though, correct?
So our enforcement power the authorization is different. That's exactly right. It's not, I wouldn't say it's less explicit in the law because it's not in the law at all. The session law never mentions who's going to enforce it. It's just like most of Chapter 504B. It's just there, meant to be used defensively by the tenants or offensively in case of the few statutes that apply to landlords for their protection. But that said, the Attorney General still has his statutory enforcement authority that would apply to the session law as well. He also has what's called parens patriae, which is our common law authority that goes all the way back to when we were colonies and you were representing the people. It means like, parent of the people. So he retains that and could enforce the legislation.
Yeah, so under the executive order, you were the exclusive entity that was allowed to enforce the governor's peacetime emergency executive orders. Was there, obviously you're not the Attorney General, but was there any conversation with the governor and Attorney General Ellison before it was declared that, hey, your department's going to be running this and be the exclusive enforcement mechanism in place of this? Did you guys have any input in the design at all?
So I have a joke first and then I'll answer. So we have this common joke. I think it comes from the office where Dwight gets promoted and he's assistant to
Yeah,
the
assistant to
general.
the assistant. Yeah.
Yeah. So we just always say to each other, like, you're not an assistant AG, you're an assistant to the AG. Anyway, sorry to reveal that inside joke that we say to each other all the time. Yes, I'm one of many assistant attorney generals, although I don't actually know the answer to your question. It happened at a level much higher than I. So I work in our enforcement team. So it's called Consumer Protection, Wage Theft, and Antitrust. It's a big division. So it's the proactive enforcement related stuff for the Attorney General. We have other divisions that work for agencies. I think that we have staff that represent the governor's office, and I have a feeling they might have had communications, but I'm not in that division and I wasn't privy to them. I just, on March 24th, got the executive order and had to make it work.
You saw it in the press like everybody else did. That was the first time you saw it?
It might have got emailed to me.
Okay, fair enough.
I have a couple questions, and sorry if you may have already said this, but you mentioned earlier 3,200 violation complaints. Were those, just to be clear, and apologies if you said this already, were those instances 3,200 that your office actually then correspond with the landlord, or is that just the total number of complaints?
Both. So it's the number of complaints we received, and we contacted and followed up on every single one.
Okay, cool. And then I was wondering, and this might be outside of your purview, but there was also the price gouging order, and I think there was a complaint form for that too. Do you know? Maybe you don't have numbers on that, but that was another thing that the office, I think, enforced, and that ended this summer, I believe.
Yep, that's right. So that also was housed within my division. So I do have some information, and I did work on it a little bit. Kind of like I said, we were all pitching in everywhere. So I did some of that work as well as the restaurants. And that, of course, was over Christmas. So that was particularly fun. But for the price gouging, it said that essential goods and services could not be price gouged during an emergency. It's kind of a common sense rule that we do not have as a law in Minnesota. A lot of states do, of course, like Florida and all the hurricane states. I mean, it's codified in law. You can't price gouge. We had to have an executive order because we do not have a price gouging statute. And in that, of course, it was food, medicine, PPE, right, masks, all of that was in there, but so was housing, because that was considered, vital to Minnesotans' health during a pandemic. You can't shelter in place if you don't have a shelter. So housing was included in price gouging. The price gouging team, if they receive, again, they also had a form, just like we had a tenant form. They were much more active in the beginning of the pandemic. That work tapered off. They received fewer complaints than the tenant form. We would often compare our numbers, a little rivalry there. And so if they got a report of a housing price gouging in terms of like rent, my rent went up more than 20%. 20% is sort of the, if it's over 20%, it's per se price gouging. It can be considered price gouging if it was less than 20, if it's, significantly above market rate, but I won't go into that. So if they received a report that someone's rent was being raised and it was considered price gouging, they referred that to our team, because frequently that would have some level of the eviction moratorium wrapped up in it. We would enforce them together.
Thanks.
I guess kind of also on the eviction moratorium, I was curious, of the 3,200 complaints, do you have a breakdown of what the most common ones were?
Good question. So I will answer that, but I have a preface, because a lot of times after these presentations, I get contacted because people want our data. They want to dig in and see who the problem landlords are. That is private data under Minnesota statutes, chapter 13. We cannot give it out. We do have an exception for giving more macro level data. So like number of reports and trends and things like that, I can definitely share that. I cannot share, not that you asked for this, Rachel, but just for people.
It's a good place to put it.
Yep. Thank you. It just reminded me. So I can never share like who contacted us, which landlords have been complained about, what cities they're in, data like that. Okay, to go to your question, the vast majority were notices to vacate. So most landlords, and they weren't even, breaking a lease. It was just your lease is up in August. This is your 60-day notice to leave at the end of August. I'm giving a 2020 example. We just had a lot of those because a lot of landlords, I think, just didn't realize that these rules applied to them. Because every time we called them, they would say, I didn't file an eviction. I said, yes, well, the moratorium is against ending tenancies as well. So that was the majority of our complaints.
Can you walk us through how that went? So from the complaint, just not a specific one, but kind of the stereotypical, oh, this is another one like the hundreds that I've done before. The complaint, and then the contact with the landlord, and then how it ultimately got resolved without you needing to file a case.
Sure. So I'd say the stereotypical call would go, I reach out to the landlord. I'm just doing me because, that's my firsthand experience, but this generally is the way most of the assistant attorney generals enforce this work. So we would call the landlord and either catch them, because they answer, or leave a message. It's surprising how many times we got a live human being on the first call. I just felt like these days nobody answers their phone, but people still do, and that's great. I love it.
Oh, let's be. You're the Attorney General's office, so people are going to pick up their phone when they call.
No, it doesn't say Attorney General's office.
What does it say?
So because we had to
St. Paul?
No, because we had to quickly get technology to call from home, not on our own personal devices. We purchased technology, and it was very spotty on the caller ID. Sometimes it said I was calling from Chicago. Sometimes it was just like kind of really random. So it didn't actually say Attorney General's office.
That had to be problematic sometimes. Well, if you're from the AG's office, why are you calling from Chicago?
Yeah, I never got that. I don't know why.
Really?
Yeah.
Okay.
So let's say I reach a live human being and I say, I was contacted by your tenant, so-and-so, who says they received a notice to vacate. They're concerned because they can't move. They've lost their job. They can't find a place, whatever the reason they don't want to leave is. Because if people want to move, that's fine. Go ahead and move. There was no prevention for moving. So we were, of course, only enforcing it if the tenant didn't want to move. So I would say they've reached out because they're concerned. I want to make sure that you're aware of the governor's executive order. The order right now applies to landlords, and it appears as if your notice violates it. And can we talk about that? So it was always a very, can we talk about it dialogue? And then inevitably they would say, oh no, I know about that. I know about that rule. I'm not violating it. And here's why. Because she has a dog and she's not allowed to have a dog. And so I told her, if you get a dog, I'm going to end your tenancy. Like it always didn't apply to them. And so I would have to say, well, I'm going to read you a little section of it. And here's what it says. It actually does apply to this circumstance. That's not the type of exception that you can have right now, depending on what phase we were in 2020 and 2021. And it would be a long call. Honestly, they were never like a 4-minute call. It was always 20 minutes, sometimes an hour, discussing it and talking about the rationale and the health reasons and the community reasons. Because our philosophy was that law enforcement's fine if you're just going to come down heavy, but it's expensive, right, to sue everybody. And so spending an extra 40 minutes to educate the landlord on why the rule was there and why it was important had lasting effects that would help us. So we wouldn't have to make those calls constantly or file lots of lawsuits. So it would be that long phone call, and I'd finally have to end it with, I hear you saying you're going to comply with the executive order. You're going to retract that notice. You're going to do it in writing tomorrow. I thank you very much. I'm going to follow up in writing. Please call with more questions. Then I would end the phone call. I would call the tenant and say, we had this discussion. Here's their concern. And often I would relay what the landlord said. Landlord said that they don't like your dog. I'm not here to opine on your dog. I just want you to know what your landlord said. They have agreed to comply. I'm going to send them a letter and I'm going to send you a copy call with questions. I said that really fast. It was much slower on the phone, but that's generally the gist. Then we have a letter that we send and we keep a copy for our file and we send one to the tenant.
Well, just listening to that, trying to calculate the staff hours from the tenant complaint to, I guess, you closing the file, convinced that the landlord is going to comply, that'd be like an hour and a half, a 2-hour average for each one of those 3,200 cases, or is it more? Do you know?
It's probably actually quite a bit more. I have not sat down to crunch that info. Maybe I will one night when I can't sleep.
That'll help you sleep?
It'll help me sleep, crunching numbers.
Right.
Don't throw shade at my joys, myself.
Right. Well, some people count sheep. Some people just do staff hours math, I guess. Yeah.
Yeah, staff hour math. The reason it's more is because that little synopsis often doesn't end the file, like you said. There's another call in a month. There's another call 2 months after that. And then, a lot of times a lot of the files that would be it. You're right. That would be it. We would close it. We would never hear from them again. And we don't have a close button. They don't close. It's just, if you call us back, we keep going. And if you don't, we stop working on it. But there were quite a number of files that would sort of blow up, and they would take 10 hours in a month. So there's no easy number.
Well, you mentioned the tenant reaching back out in a couple months. Is there a percentage of the calls that you had where 10% of our callers, the landlord tries it again in a month or 2 months?
So I have no actual numbers, but anecdotally, just, from my recollection of that era that I've tried to black out, I'm just kidding. I would say about 30% would linger, call back again for something else.
So the landlord would try a different approach later, and then the tenant would have to reach back out.
Yes.
Wow. Okay. That is a higher number than I would have thought. Okay. I don't mean to monopolize the time here. Eric or Rachel, feel free to dive in.
Do you have a question, Rachel?
I'm just going to say that there are only about 3 questions in the Q&A, and most of them are not specific to the Attorney General stuff, so I've been holding off on them. But reiterate a plea, if anyone has questions for Katherine, while we have her here, she's a font of information. And so if you've got questions, please put them in the Q&A and I will jump in and ask them.
I do. I have another question. I think it was sort of thought that Minnesota's moratorium, governor's peacetime emergency, and the various executive orders 2014, 73, and 79 were at least comparatively to other states, including some that didn't have anything and just were relying on CDC moratorium, somewhat stronger than a lot of other states. I'm wondering if there was if you have colleagues in other states that you talk to, and if there was any sort of like here in such and such a state, we're also doing similar type of process, and both, I guess, what the protections were, but also sort of the actual workload that was happening in the other states, if any other AG offices were tasked with that.
Yeah, I can definitely speak to that for a number of states. So it's a patchwork throughout the country that varies wildly. From our pretty strong protections here in Minnesota to zero protection of any kind in more than half the states. And in those states, the CDC rule was the only one that was protecting tenants, with some mixed results. I think the eviction lab out of Princeton pegs it at about a 50% reduction in eviction filings in states that had no other protection, where just the CDC rule applied. I think it was like 42%. Anyways, go to the Eviction Lab website. They've got all that data. So, but the more protected states were, unsurprisingly, Washington, New York, Washington, D.C., not a state, Massachusetts. They had very strong protections from their governor. Although actually Washington did not. I take that back. I talked to an assistant attorney general there. For some reason, they weren't able to get really strong local rules. So they were actually taking the CDC rule and like really running with it, their office. So anyways, their office was very proactive in protecting tenants. That said, even though some states had really strong protections, there were not the strong enforcement that I think Minnesota had. So Washington, D.C. had, they would take a report. I don't think that they had a special form, but they might have, but nobody received phone calls, and the tenants did not receive anything from the office. But I think that the Washington, D.C. office only sent form letters to the landlord that said, we received a report that you're violating Washington, D.C.'s eviction, protections, and here's the protection, and you better comply. And I think that I don't think that there was any follow-up there. So, it's not as robust, I think. New York, they had a little bit more because the New York Attorney General's office actually has a housing unit. It's a very large division within their office in many of the locations in their Albany office and their New York City office. And I think that they have about 20 attorneys in just their housing division. So they were doing work on that as well. Interesting note, New York just lost their eviction protections. It was just ruled unconstitutional by the US Supreme Court on a technicality. So they've completely lost all of their state protections, and they're now relying on the CDC rule as well, while they probably revamp their rule to comply with the Supreme Court's order. So it really runs the gamut, Eric. And I don't know that I know a single state that was more protective and more vigorous in their protections than Minnesota.
Well, thank you. That's very interesting to hear and good to hear too, I think, for our clients. And I guess one other thing on that front, I know we've been kind of monitoring, and maybe I'll try to find the article and put it in the chat. There's been some articles about data from the National Low Income Housing Coalition, which is compiling, the rollout of federally of rental assistance funds from the first round of rental assistance funds, and kind of comparing it between states. And there are some states, I think, and I want to say New York's on that list. So I'm not sure if maybe their moratorium and their protections there maybe help facilitate how rental assistance worked. But was that a part of any, I guess it's not really part of the enforcement, but probably something that you maybe got questions about, or was a part of conversations you maybe had with tenants, is just that while you are behind and the landlord can't take these actions, this is something you can do to get caught up on rent?
So we were, heavily pushing any rent assistance that existed, before rent help. And then there were, kind of patchworks between cities. Minneapolis was rolling out its own fund. There was aid money. It was kind of, again, like a patchwork. We were heavily pushing that because, we told, again, it was education both for tenants and landlords during COVID for us, because tenants would feel too comfortable sometimes with their protections. And they would think, well, I don't have to pay rent. And this is not at all across the board, but there were a few out there who would say, I can rest easy. It's fine. I'm protected, even if I can't pay. We would encourage them to always apply for rental assistance, even though they were protected, because, the axe was going to fall one day. And the farther behind you get on rent, the more likely your landlord is to file for eviction when they can. So we were always pushing for people to get the rent money. Also, landlords just need it, right? The landlords don't go into business to be a charity. They have bills to pay. So they needed the rental assistance money as much as the tenant needed housing. So we were always encouraging people to apply for that. And the money rollout is, and this isn't what your question is, but I'm going to say it anyway. The money rollout is actually a big reason why there are still federal protections. So, we all know, well, you guys know, and most of the viewers probably know, that Congress passed is it $43 billion in rent help for the country nationwide. And they put in place a lot of guidelines actually on how that money can be used. And rightly so, that's taxpayer money. We don't want it going into fraudsters' pockets. So there's quite a bit of red tape that states have to jump through to get that money out, to do it right. And the rollout is very, very slow. I think as of a month ago, 3 billion had been given out, and that's far slower than I know that anybody wanted it to get into the hands of tenants and landlords. So because of the slow rollout, that is one of the reasons why we have the longer protections than anyone thought. I never thought in a million years last summer that I would still be doing this work this summer. And it's because all those tenants out there have owed rent, $3,000, $10,000. And they've applied for rent help, they're eligible, it's going to come, but it hasn't gotten them to them yet. So letting a landlord file an eviction action before that check comes in the mail would just be a travesty. The landlord would miss out, because in Minnesota, tenants have to be in the home in order for the landlord to get the money. If they vacate before the money comes, the money doesn't get in the landlord's hands. So it would just be horrendous if we allowed evictions to happen before the money gets in the hands of those who need it. So that's why Minnesota's off-ramp legislation is tied to the money and when it's received and whether there's an application pending. Similar to the CDC rule, was extended to October 3rd because of the slow rollout of money, as well as the Delta variant being increased. So it's all connected, Eric.
Someone was asking in the Q&A, actually, very similar question. kind of, I think, just a cry for help, but does anybody have any power to get Rent Help Amen to speed up on funding? And
I feel your frustration. I
Right.
hear it. Yeah, we get those calls as well. And I'll just be explicitly clear. Our office has zero to do with that. It is managed by Minnesota Housing. They are trying to comply with all the rules that they were given. They have partnered with community agents to get the money out. And I think that they are just facing a worker shortage, honestly. So what can someone do if they're frustrated by the rollout? I think that, well, so Minnesota Housing is a government agency. It's under the executive branch. It's under the governor's office, technically. So I always encourage anyone who has a problem with government to reach out to your representatives, reach out to those who pull the strings of what happens in state government. So, write a letter to your Congress people, write a letter to the governor, let them know how it's affecting you and how the rollout, is frustrating you. Communicate with your government. That's all I can offer. I'm sorry.
That's fair enough. And I just put that link in the chat to that color-coded map that I was mentioning. I think what's important to mention is that while it is kind of widespread throughout the US, there are some states that are getting it out there, like New York, it shows over 50%, Virginia, Texas, over 50%. So, I mean, it gives the perspective that, it is possible to get that money out faster. And so, continuing to encourage government to make that happen is important. But we have a little over 15 minutes left and a few in the Q&A. So should we transition to that, or?
I have one that I think transitions nicely between that is Rent Help MN related, but I also goes with a question that I had for Katherine about whether the AG has anything to do with fraud, like investigating fraud within the Rent Help MN program.
So we would encourage anybody to report it to us. I don't know that we would be the office to pursue the investigation, but we definitely would be a good clearinghouse to refer those over to the right entity if we aren't the right entity. We do get a lot of PPP, that's the Paycheck Protection Program, reports of fraud, business that doesn't exist, took money. And we know which of our, federal law enforcement offices to refer those to. So if someone doesn't know where to go, feel free to report it to us and we will send it to the right location.
Perfect. And I do believe that the Rent Help MN website also has a report fraud option as well. So that's another option. Perfect. Thank you, Katherine. I thought that was a good transition between everything. All right. And yes, if you have opinions about these upcoming questions, feel free to chime in. We always enjoy others' opinions about these things. Okay, so lots of anonymous questions. So first one is, if a resolution has been reached in a conflict resolution center that both the tenants and the landlord signed in front of a mediator, is that a legally binding agreement between them?
So I think this can be sort of probably lumped in with almost any settlement agreement, right? I mean, it can serve as a contract between the two sides. And so sometimes, depending on how these sorts of things are worded, there's an enforcement mechanism built into the settlement agreement. And in the case of, for instance, evictions, if let's say that the case has been filed and there's a settlement reached, the tenant usually has to do something by a certain day, pay a certain amount of money by the 10th of the month or something. And if they don't, then on the 11th, the landlord is entitled to go get the writ instructing the sheriff to remove the tenant from the place. And so if there's an enforcement mechanism built in, then it's quite a bit easier to enforce the agreement. But in general, I mean, people contract all the time, and you can't have a contract resulting from a mediated agreement or a settlement agreement.
Perfect.
And I'm just trying to jump in here and get my video working. I was just going to say, we're going to, since most of the questions here are related to tenant landlord law that I think we can tackle, we're going to say a quick goodbye to Katherine Kelly. And a big thank you to her and the Office of the Attorney General for joining us today. Thank you for walking through the last year and a half of the work that your office has been doing, and sharing the statistics and information with us.
And if I could, Catherine, I wanted to publicly thank the Attorney General's office for their work on this. We felt very comfortable referring people to the Attorney General's office during the peacetime emergency when we thought that there was any chance that the executive order would come into play. We knew that they were going to get heard, and probably heard pretty quickly and dealt with effectively and efficiently. And it couldn't have been easy to start that process and make it as well-oiled a machine as it turned out to be. But we are deeply appreciative for the work that the AG's office did during that time.
My pleasure. Thank you. That was very nice. Bye, everyone.
Thanks, Catherine.
Right. So then I'll just plow through these. We have a little less than 15 minutes left. So
Sure.
We're at 6 questions. I think should be fairly straightforward. And the first one is more of a, okay, so sorry, things have shifted on my screen. So the next one is more of a complaint about the process, venting some frustrations from a landlord who wishes that there had been some sort of timeline that a tenant needed to adhere to once their circumstances had changed and then fell behind on rent, a timeline for which they could be limited, that they had to apply for the rental assistance within and not whenever happens. I guess I have a comment to that of like with the off-ramp phase out, whatever you want to call it, went through about 6 months of negotiations at the legislature. So I think just about every thought was bandied about, and this was the compromise that was come to. So as Catherine was saying earlier, if you've got concerns or if it's something that's coming through your that's impacting you, talk to your Congress people about it. That's their agreement, essentially. So that's a good place to start with this sort of frustration.
You mean state house and state representative
Yes.
members, right? Sure. Yeah.
So the actual question, again from anonymous, under the phase out, if a tenant leases ends on October 31st and the lease has a 60-day notice to vacate clause, would a notice given September 1st be effective, or would notice have to be given after the October 12th phase timeline?
Yeah, so we've been looking at that issue since the day it was ordered. The session law was issued and agreed to. Our view, and we haven't litigated it yet because it can't be litigated yet, but our view is under the language of the session law that a landlord has to wait until October 12th to be able to give a notice to vacate or a non-renewal, which means for most leases, even if the tenant is month to month, the landlord might have to give a full rental periods notice, which would mean the end of November. Many leases, even if the original 1-year period has ended, all the terms remain in effect. And so a 2-month notice is required. So that landlord would be giving a notice probably for the end of December of this year would be the earliest they could give a notice. If it's a 60-day notice, most leases require that notices are given directed towards the last day of a rental period, whether it's the landlord to the tenant or the tenant to the landlord. So I'm guessing we're going to see a lot of notices given for the end of November and the end of December. We certainly have seen landlords trying to give these, I think, premature notices to vacate, but I don't think they'll hold up in court. They shouldn't, based on the way the session law is written.
Awesome. Thank you. So this is anonymous, but I also believe a landlord. They're saying we have tenants who are on a month-to-month tenancy. They are several months behind on the rent, so we sent them a notice that we are not renewing their lease effective September 30th. They've now applied for assistance, but they admit their income is too high to qualify, and good luck getting them to complete the application process. They will stay. So I think this is maybe more of a comment than a question.
Yeah, and I mean, there's pieces of this that the landlord might be able to win an eviction case at various phases of the off-ramp. And we have on this presentation, we have had a landlord attorney named Kim Tennyson on several times. And I would recommend that you contact her and see if you think that there's enough there to go forward with a case, frankly. It's an anonymous submitted question like this, it's a little bit difficult to say, yes, you're going to win. No, you're not going to win. There's a lot more detail that would have to be learned to give you a better assessment. But there's a possibility that the tenant might be evictable now or might be evictable next month, or depends on what happens with the CDC moratorium as well. There's a lot of moving pieces here, and they keep moving. And like I said, I wasn't joking when I said I thought that there was a chance that during this presentation, the Supreme Court would change the rules again. That still could happen. But yeah, I would recommend you get in touch with Kim Tennyson or some other lawyer that works with landlords.
I was just going to add to that. I mean, it seems, and maybe you touched on this, I was looking something up, but it seems like the assumption should be someone is eligible. If it just seems not that feasible that in most of these cases, a landlord would have enough information to determine if somebody's eligible. There's the income eligibility, or there's other eligibility requirements, and so it seems like, you know, before you put, like Mike said, talk to a lawyer first, but you might want to just assume before you go about spending money on pursuing an eviction that somebody is eligible until it's clear that you know, they've been denied from the program.
I mean, a lot of landlords are simply working with their tenants to help them figure out how to apply. There's some larger landlords that have hired staff members to do nothing but that right now, to assist tenants in applying for the money, because it's in everybody's interest. It's in the landlord's interest, it's in the tenant's interest, believe it or not, it's in the court's interest. They don't want all these cases. It's in society's best interest. And so if you can get that communication line open to convince the tenant to apply, and maybe convince them that it's not as difficult as they might think it is, or show them the way to do it, might be the best use of your time as a landlord right now, trying to get the money.
That transitions very neatly into another anonymous question. Actually, it's two questions from this same person, but they're saying what documentation is needed to prove a tenant is ineligible for COVID-19 rental assistance. That's a question we get a lot, and we kind of just covered some of it.
If you don't mind answering that one, Rachel, that's fine. I mean, you've done more with rent help folks than I have as well.
And the consistent answer is it depends. You know, if you've only got your, say, the income information you got when somebody applied, you know, 2 years ago for the space, that certainly may have changed. So it's probably not going to be very effective evidence. But basically what it boils down to is the burden is on the landlord. A outright denial from Rent Help MN may be a good indicator that someone is ineligible, although those things are appealable, so it's not as airtight as one might think. So the requirements, the eligibility requirements are listed on Rent Help MN's website, and so that's a place to start to determine eligibility or not. I was going to go on to the second question in this, Eric, so if you had something else to add to that.
I mean, I just reiterate, like, yeah, you can look up from a landlord's perspective, you can look that up on I think it's on the resources page of the Rent Help MN. But I think it's a bad idea to assume that you know someone's eligibility status or not. I'd also just add to this that, you know, this is again part of what Rachel said earlier, negotiated phase out law that was negotiated by a lot of parties at the legislature, and this got discussed. You know, there was multiple agencies that I think testified, well, how does a landlord know if somebody's eligible? So that's why this particular next step with the phases is a bit of a complicated one, because that's not easily determined.
And the second part of this question, moving on, is that does the requirement just include ineligibility for Rent Help MN, or are other forms of rental assistance included?
Which is in the session. I don't have the session law pulled up in front of me.
It has to, I have it here.
The phrasing is,
It is, the rental assistance programs have to have been funded under these two federal laws, Consolidated Appropriations Act 2021 and the Federal American Rescue Plan Act 2021. There are multiple programs in the state. There is Rent Help MN, there's Zero Balance Project. There are some counties, like I believe Ramsey County has a pipeline where tenants can directly apply, and it is the same funding program. And then there are tribal entities that have this funding and are eligible. The rental assistance programs that they have are eligible under this program.
so if there was a new program passed tomorrow at the congressional level, that would not qualify based on how the session law is written, right? You have to apply under one of those two programs you just mentioned.
Well, and those aren't programs, to be clear.
Well-
Those are acts that appropriated money to the states and to local entities and to tribal entities. And so yes, if there was new funding that came from the feds, that's probably right. But also, one of these municipalities or the state could create a new program that, if it was using the same funding from these, would feasibly be eligible.
All right. Are landlords who accept Section 8 vouchers covered by the CARES Act?
Again, our involvement with the CARES Act is pretty minimal. I think it covers all HUD sources of income or sources of housing subsidies. Eric, is that your understanding of it as well?
I believe so. I haven't looked at that in so long. But
Right.
I believe that's true.
But I think that's right. We estimated that maybe 20 to 50% of buildings in Minnesota were covered when this was a really important question a year ago. We tried to figure out what we thought it would be our best guess, and that's a pretty broad range, 20 to 50% of the housing in Minnesota. And so I'm pretty sure Section 8 vouchers were covered by that, but we haven't had that litigated in this state, obviously, because it hasn't played a role yet.
Okay, and this is the last question from Carla, a advocate with a shelter, and they're asking, they get calls about people being told by the landlords to vacate, and they just want to clarify, should they be adding the individual or telling the individual to contact the Attorney General's office on top of Homeline for resources when they have people call them?
Oh, Catherine left too soon. Yeah, who knew? Yeah, so the AG's office, and we didn't really talk with Catherine about kind of what they're doing going forward as much as what they're still covering when it comes to the peacetime emergency. But the Attorney General's office takes consumer complaints from people in a lot of different arenas, not just housing, but they certainly do take complaints from people in housing. And so I don't think that, I can't speak for their office, but I think they'd be okay with a tenant contacting them with an issue. As Catherine mentioned, they can try to enforce things under the umbrella of 504B, which is the state landlord tenant law chapter in Minnesota. The Attorney General's office always has that inherent authority. The big difference between now and when the peacetime emergency was in place was there was an order telling the world that the Minnesota AG's office was the only place that could enforce the governor's order. Nobody else really had any power to do anything. A tenant couldn't go file a lawsuit against a landlord under the executive order, at least not directly. It had to be the AG's office enforcing it. So that was why the AG's office had such an outsized role during the peacetime emergency versus normal times, which we're getting closer to now as far as landlord tenant law is concerned. So the long answer is yes, they should call the AG's office as well. There's not much of a downside to that.
They just shouldn't expect an answer back. Like
well,
before.
not an immediate answer, and
Yeah.
and it might not be as involved for sure, but the AG's office can only work on what they hear about. And so if they don't hear about certain issues from tenants, then they won't take any part in it. So they need to hear from folks that are living with problems.
And Catherine did put the link in the chat to the online complaint, which is available in multiple language, but we'll include that in the materials with the recording on our website from today, which will be up in a day or two. I actually did just really quick run and check Larry's guide, Larry McDonough, who was on our seminar last year, and CARES Act does, covered property does include properties that participate in a subsidy program covered by VAWA, which is Section 8 Housing Choice Vouchers is covered in that.
So we were right.
Yep. All right, we got through the questions. It's 3 o'clock, and we're just gonna say thank you to Katherine Kelly and the Attorney General's office, and thank you both, Mike and Rachel, for speaking and presenting questions today. And a reminder, and I'm trying to find the link in my notes here. Here's the link to more info, and again, registration is not required for our seminar that is in 2 weeks. We've got a different seminar, a webinar coming up. We're skipping next week, and then the following week on Wednesday, September 8th, it's in the evening, 6 o'clock, and it is a session, multilingual, broadcast live in English, Spanish, Somali, and Hmong languages, and designed for an audience of tenants and advocates and other individuals who are working and speaking to renters who are impacted by the phase-out law and need to know their rights and their responsibilities under that. So please visit our website, and you can sign up for a reminder email the day of so that you can join that seminar that night. And we will be announcing more webinars throughout September and possibly October in the near future. So thank you for joining us today, and have a good rest of your day.